What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is Tuesday, March 18th. We're going to recap Lori Vallow Daybell's hearing from earlier today. I want to make a correction to a YouTube short that I put out earlier. In that YouTube short, I said that Lori's assistant counsel indicated she would take the stand in her own defense. It was actually the prosecutor who said, based on a filing, it looks like Lori is likely to take the stand. I did put a correction short out there, but just in case you didn't see it, I wanted to make sure I was clear on who said that. At the start of the hearing, Lori asked the judge if her investigator could sit at the table with her for this hearing just in case she needed to ask him something, and the judge allowed it. The judge said they will be using Judge Kemp's courtroom for trial. That is in the South Court Tower. So if you're planning on trying to make it for a day of testimony, that's where you will need to go. A lot of people have asked me about crowds, and I really have no clue, but I would anticipate this is going to be a hot ticket for a lot of people, especially locals who have followed this case. So we'll know a day or two in how these crowds are going to be. But I think it's fair to say if you're wanting to go in and watch some of the proceedings, you may want to get there really early. The judge gave both parties a proposed jury questionnaire. He said there's probably more questions that both sides would want to ask, and he wanted to let them know that what he's proposing is not limiting. The judge said he would go over the burden of proof and the credibility of witnesses with potential jurors, and a lot more that's just not in there. This is more for bigger issues like pretrial publicity, opinions on Lori or the case, their exposure to the case, the victims of the crimes, and if they or close family members have been charged with a criminal offense, and if so, he would have them explain. The prosecutor said her concern is when jurors come in and they're hearing the case, they will likely hear the names Tylee and JJ. She says there was more publicity about them than there was for Charles, and to ensure they get an unbiased jury, as well as pre-trial publicity exposure regarding Lori, they will have to question them about her prior convictions in Idaho. The judge says that may happen in individual voir dire. With what he currently has, if they recognize the name Vallow or Daybell, they would need to tell if they're familiar with her and the Idaho case, and he does anticipate losing a number of jurors just based on that. Some may say that they have been exposed, but it wouldn't impact their ability to be fair. He doesn't want to taint the jury pool by telling them about her convictions in Idaho. The state says they don't propose talking about those Idaho convictions, but the jurors are going to hear the names JJ and Tylee in the trial. The judge said he could put their names on a sheet which lists people that the court would want to know if a potential juror is familiar with, people that may be referenced during the course of the trial but will not testify. And the judge asked Lori if she has any objections to naming Tylee and JJ, and Lori says no. The state has 21 listed witnesses, and jury selection could take longer than a week. The dates they are giving potential jurors for trial is April 7th through May the 15th. That's 20 full days of trial and 2 half days, which makes it a total of 21 days of trial. He asked if they really need to screen that far out. He said he understands everybody's being overly cautious. The prosecutor said she's not positive they will actually pick the jury that first week. She does think that time frame is fair. Lori says she thinks that is plenty of time. They move on to talk about that video that Lori had requested from the Gilbert PD. We talked about this at the last hearing where her mitigator said there was a 2-hour video available online, and Lori had filed a motion for the state to disclose that. The state says they've gone through the police report and they just don't know what video she's discussing, and they're not aware of any video that hasn't been disclosed to the defense. Lori says for clarity, is the state proposing there's no video or that they don't have it to give to me because it's not attached to that DR number? The judge says, I think what she said is she is not aware of what video you referenced and she just doesn't know about it. Lori asked the judge if she should go directly to the Gilbert PD about it. And the judge says, the last time we were in court, you said your investigator told you about it. Lori corrects him and says, mitigator. And the judge says, if your mitigator has that link, maybe send it to the state and see if that's something they've already disclosed. Lori says, I tell you why they won't. This is my former team, and they won't do anything to help my investigator, my paralegal. They won't give us any information they found. And apparently it's because there was a conflict. So they won't help us. They won't email us. They won't send us anything we ask them to. And that's where we are. The judge asks if they turned over a file to her or did she start from scratch? She says they turned over the 22 terabyte hard drive and that's it. No notes, no work product, or nothing they did up to that point. Just for reference, y'all, I did a Google search of how many pages would 22 terabytes be. And if I did it correctly, that would be about 1.7 to 2.2 billion printed pages. Holy moly. That is a big, big, big file. Lori said even though she gave them a lot of that information, they won't give it back to her. The judge said he would make a detailed order for them to turn over their entire file, including any mitigation information that was gathered. They should have done that when they withdrew. For a couple of minutes here, the judge silently reads through some filings and asks if the state has received a response from the defense. The state said at 10:30 last night, the investigator sent addresses for the defense witnesses, and she's unclear if the defense will be setting up those interviews for the state or if the defense will provide phone numbers for the state to set those up on their own. As for the defense expert Lori plans to call, this is a digital forensics expert. The defense investigator emailed the state late last night wanting to obtain the physical cell phones and laptops taken by investigators so that their expert witness could do his own extractions. The state points out, so the investigator hasn't even begun work on this, and the defense has requested all impounded items. She's not clear if this is stuff from Idaho as part of their investigation or from Arizona. The statements from Lori's investigators seem to indicate all of them, which means the state would have to request those from Idaho to send to the investigator. Given all of those issues, the state doesn't see how it's possible for the state to get this to Lori's expert before trial beginning, let alone get a report or an opinion prior to trial beginning. The judge wants to set that aside for the time being, and he asked Lori's investigator, whose name is Jeff White, if he will be setting up interviews for the state. He says he is trying to verify that phone numbers he has are correct. Lori says her understanding is the state has interviewed every person on her witness list previously. That's where she got the names from. She says she understands that they're allowed to do another interview, but they've interviewed everyone but Nate Eaton from East Idaho News. The judge asks if by interview she means by the police or the state. Lori says in discovery she has every interview that was done by the police. She knows they had their addresses, but where she is at the jail, it's hard for her to get in touch with her investigator and paralegal. And she points out she is on lockdown 23 hours a day. If she has no Wi-Fi or no cell phone battery, that means she has no phone. She says she's doing the best she can to get things answered and put together. The judge says, as a threshold question, your assertion is all the people you've listed as witnesses all have relevant information for the trial? And Lori says that's correct. The judge asks if she knows if the police have already interviewed these people. The state says the first person listed is a reporter, and she's not sure of the relevance. Lori interrupts and says that Nate Eaton is the only one that has not been interviewed previously. The state says, I'm not sure all of these people have been interviewed, and those who have, it would have been 5 years ago. So whether their addresses are correct, currently it's unclear. It's not the state's responsibility for the state to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. But as far as the witnesses, most would be character evidence, which would be improper under Rule 405. So, depending on what they say, she would need to file motions to preclude or motions in limine for any or all of these witnesses that Lori has listed. The judge says it's a bit premature to address this today. The state will need to interview them to see if they have relevant information or not. And if there's a dispute, they'll deal with that as it comes up. But if these witnesses are unable to be located to interview, obviously they won't be called at trial. The judge tells Lori if she wants her expert, Mr. Dworkin, to do extractions, she's not going to be ready for trial. In order for him to get copies and do the work, it takes time. It takes time to extract, to analyze, and then to do reports, and that could take months. Lori says she understands and hopes that her expert can do this in an expedited manner. She said she requested to hire him on January 14th, and he wasn't approved until March 7th. The judge points out, you're the one requesting a speedy trial, so you have to make a decision. Do you want to head for trial, or do you want your expert to do the work? Because I don't think both are going to happen. Even if you were to get these electronics today, those things take weeks or even months to analyze and prepare a report on. Lori says she understands, but she's only been approved for 10 hours for her expert. So if he could spend 10 hours this week and give us a report, he can do the best he can do. The judge says that the report is already late technically. So what are you requesting? Are you requesting items from here in Arizona or Idaho? Lori says her investigator would like to have all of those, but because of the time constraint, she is only interested in one item, and that is with the Chandler Police Department, which was Charles's cell phone. Her investigator whispers to her, and then Lori says she would like a copy of the extraction that the state did. If the digital forensic extraction they did could be given to him immediately, that would work. But the judge asks, wasn't that already disclosed? And the state says, yes, it was. Her investigator said everything he has is on that 22 terabyte hard drive. So if he gave that away, he can't do his work. The judge asks, can't you make copies? The investigator says, it's 22 terabytes. The judge says he understands. And he asks the investigator, what's your proposal? I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabyte drive, but there's a file somewhere in there that has that Celebrite extraction that's been in the defense's possession for however long now. The judge says he's happy to make an order, but if her expert is not ready with that information, do you still want to proceed to trial? And Lori says yes. The state says depending on what the defense expert says, and the judge interrupts and says it still could be precluded depending on what his opinion is. And first of all, it's late under the rules of evidence and disclosure. And second, depending on what he says, the state would have the opportunity to consult with their own expert as well. So even if he's got something done, it could still be precluded. But the judge says, I'll still give him the opportunity to do whatever you think he needs to do to analyze that. But that information has been with the defense for months, if not over a year. The state says more than a year. Lori says her expert was just approved last Friday. The judge says again, this is where you have to weigh your options, whether it's worth it to get a continuance to get the work done you want for your defense. But if you're telling me you don't, Lori says, I would like to do that, but the situation in my housing department precludes me from doing that. The judge says, to ask for a continuance? Lori says, no, getting things done in an effective and quick manner. The judge says, so you're telling me you don't want a continuance? Because at this point, anything could be precluded as being untimely. Lori says she understands, and she understands how unfair and prejudicial it would be to her. The judge says that he will have to make a decision if these defense witnesses have relevant information and if they can be called at trial. The state says, obviously, we have a little over a week to try to interview these people. She will file something next week, including who she was able to interview, and then ask to preclude everyone else. The state says the only motion they did not address is an indication in a filing that Lori will likely be testifying. Lori said she was not prepared to address that now. He tells Lori, if you choose to testify, it's likely the jury will hear about your convictions, but at your request, they could be sanitized, meaning they would only hear Lori has a conviction as opposed to the nature of those convictions. And then the jury would be given a limiting instruction that it could be used to determine credibility. If you do want to testify, you need to write out all of the questions you want to be asked by your assistant counsel. He tells Lori she cannot get up on the stand and give a narrative. It will be question and answer. She asks if she will need to respond to the 609 if she wants that sanitized, and the judge says they will address that when the 609 is addressed. Rule 609 of the Arizona Rules of Evidence, by the way, it governs the use of a witness's prior criminal convictions to impeach their credibility, specifically allowing evidence of convictions for crimes punishable by death or imprisonment for more than a year. As far as openings, the judge said we talked about your being limited to the podium, and then your investigator or advisory counsel will approach witnesses if something needs to be handed to them, and the same with the state. They'll be confined to the podium, and then someone would assist with approaching witnesses with exhibits. Moving on, Lori says she has motions she would like to file. She said her paralegal was busy and she doesn't have copies. The judge tells Lori he will have copies made and give those to the state. He will rule as the state's responses come in. Jury questionnaires will go out starting on the 24th, and the deadline for that would be the 27th. The judge says that he will meet with both parties on the 31st at 10 a.m. to go over those responses. And starting April 1st, they will meet at 10:30 every day for jury selection. The state says there may be days they have to end a little early on some days during trial to accommodate witnesses that will be flying in. For the second trial, this is for the attempted murder of Brandon Boudreaux. As of now, jury selection is set to begin May 31st. The state asks, will they put in Lori's witness list? And the judge says he will put the names in just on a preliminary basis. Lori asks, where do we stand on the video we requested? And the judge says the state says they've given everything they have, but he will order her prior counsel to hand that over if they have it. And she also needs to figure out what video she's talking about. He says he will give that to her advisory counsel if they do get it. He asks, do you want a broad order of everything they have in their possession? Or to save you a lot of time, do you want it pointed? Lori says whoever showed her this has the link, but prior counsel said that would not be given to her. The judge asked for that mitigator's name, and Lori gives it. Lori asks if they need an order to pick up, and she says this, my husband's phone, Charles Vallow, from the Chandler police, so her investigator can do the extraction. And the judge reminds Lori, you already have that extraction. The prosecutor said she would need to draw up a release, schedule whoever is going to pick this phone up, and have Lori sign a release saying she acknowledges if something happens to the device, she weighs having that device available to her. The judge asks if they would do the extraction of that phone at the police department, and the state says, I don't think they would allow them to do it there. The judge says they can draft a chain of custody agreement, and if Lori signs, the investigator could just go pick up the phone. Lori says that's perfect, and then she says, but logistically, how's that going to happen? The judge said your investigator will bring this waiver for you to sign, and that was the end of the hearing. So we are getting close, less than 2 weeks to trial. It's going to be very, very interesting to say the least. And then not too long after, justice for Brandon. And then the judicial side of all of this, over 5 years in the making, will be over. That is it for today. Hope you guys have a good rest of your evening, and we will see you soon.